Texas. Along with me is my business partner, Emily Neumann. Today, what are we going to discuss, Emily?
All right, we're going to be talking about the latest updates that we got from USCIS on the adjudication of the 485s. Are they doing great? Are they too little too late to avoid wasting all of the green cards like they did last year? So we'll give you an update on that. We've been hearing a number of situations where someone gets their green card approved and the approval comes in the wrong category. And so we want to talk about what's causing that. Is it really the wrong category? Is there something that you need to do to fix it? Also, lots of questions about how can I use my old company's I140 and EB2 to be able to upgrade from EB3 back into EB2? Is that possible? Is it working? Are people doing it? And also, just remind everyone of the timeline for the green card. Obviously, it's way different than it was just a few years ago, so it's very important to start the process early. So we wanted to discuss that today. Also wanted to update you that we're in the middle of a storm here in Houston and our lights keep flickering. So if we lose power, it takes us about 5 minutes to restart everything. So hang out and we'll be back as soon as we can in case we go off.
Since this is a live session, guys, we want to get more questions. So this is not a recorded session, so that's the reason why if the power goes off, please hold on for about 5 minutes before we come back. Emily, first I have to say the USCIS director urged Jaddou a good applause from my side. I know you have some disagreement. I saw your interview in the Bloomberg. You're not that happy, but overall I'm much happier because she's been doing very good. I mean, previously we have released so many things saying that she's just a talker, she doesn't do any action. Seems that she's doing good action. According to the stats though, the first 3 months, the 485 applications approved on the employment based was only 33,000 green cards for the entire 3 months. That is for the month of October, November and December. Now, when it comes to until May of 2022, they actually adjudicated 149,000 green cards. So if I deduct the 33,000 they adjudicated in the first 3 months, then it's coming out to be approximately 23,000 green cards every month they are giving, which is a very good pace. If they go at this pace though, Emily, they are expected to waste about 40,000 green cards. We still have June, July, August and September month, which they didn't release the statistics of the June. So if they go at the same pace, they're going to waste 40,000, unlike a lot more last year. And we do have extra more green cards than compared to last year. So they will still be wasting 40,000 green cards though. But if they increase the pace by about 10,000 per month, so they're going to use all 280,000 green cards that are available though. But when I look into the article that you published it on Immigration Girl, the stats from our office, how many 485s are getting approved in each week though, when I look into the list of yours though, it's very clear that the month of June, there is a definitely increase in pace of adjudication than compared to the previous month. Of course, it's been continuously improving it, but when I see the difference between May and June though, I do see that that they may adjudicate the 33,000 green cards, which if they go in the same pace though, they may actually complete the entire 280,000 green cards. I know you're being a bit skeptical. What's your opinion on that?
Yeah, my concern is up until this point, all of the times that we got the numbers on the number of adjudications, it was just USCIS. Then we get this update on Friday, and now they're saying, what, 149,000 are approved through May 31st, but now they're adding in Department of State approvals. So it's not just USCIS that's gotten us that far.
But in general, Department of State only adjudicate 5 to at the most 10% in the employment-based generally.
I agree, but they also are dealing with the backlog of 2 years of being closed due to COVID. So they're using a lot more employment-based at the consulates this year compared to any other year before. And we just don't know what the differentiation is.
So do you mean to say the 23,000 green cards every month that I put it from the month of January to May, there may be some of them that have been approved in the first 3 months in the Department of State?
We don't know.
No, yeah.
Yeah, we have no way.
But either way, Emily, if they adjudicate the applications in the pace at which they did in the month of June, and in July also, I do see a lot of approvals from our desk. It seems that they may hit the 280,000. Now, what we want them is to use the 280,000 green cards. Whether they do with the Department of State or whether they do with the USCIS, it doesn't matter. The people got the green card, they didn't waste the green card. However, you are a bit concerned that the pace at which they are going right now doesn't look like they are going to approve the 280,000 green cards. Yeah, you may be right. Hopefully so, I'm right, not you. But we want you guys to keep the pressure on the USCIS. We want you to guys keep the pressure on the Congress. We want to keep the pressure on the administration. We have drafted letters for you. Please keep writing. It's paying off. Compared to the last year, you agree with me that compared to last year, USCIS is adjudicating much better this year,
yes.
Which you agree. Thank you for it. So it's because of you guys writing the letter. Is there any response we got from any congressman or senator recently on this adjudication?
Well, we did get an update just recently from a couple of representatives who were reaching out to the Department of Labor, actually, about their delays in perm processing and more on the prevailing wage processing. They are concerned about that because it's now up to 7 months it's taking to get a prevailing wage. That's delaying H-1Bs, H-2Bs, as well as the actual perm for many of people that are in critical need right now. So we do see a lot of advocacy happening, and it is helping to continue to put that pressure on all of the agencies involved.
The reason why we want all these people to get the green card is that if these green cards are not given in this fiscal year, which ends on September 30th, these green cards will be wasted. They go in trash. They will not be able to, nobody will be able to use it. So to keep the pressure on the Congress, please, on the administration, on the USCIS, please keep writing letters. Please keep writing letters. The drafts have been given. Emily, the most common consultation that I'm getting right now is that, oops, I'm happy my green card is approved, but it's approved in the wrong category. I'll tell you some of the examples of it, and then I want solutions for it. I want feedback, what you got from the USCIS. My priority date is 2013. Okay, I have my EB2 I140 approved, and then I interfiled in EB2. I got my green card approved, but according to the green card though, I got approved in EB3. What's the problem? What's the solution for it though?
Yeah, so obviously if the EB3 priority date is not current at the time you've received your green card in the EB3 category, it makes it look like either it's approved in the wrong category or it's approved when there's no green card available to you. And we have seen this in a number of situations. So we first started out with doing a Freedom of Information Act request to get a copy of that 485 file to see if we could verify which category it was approved under to see, made sure it matched what was on the approval notice and the actual green card. Our next step, we reached out to the Ombudsman office to try to figure out what was going on. Because in this case, there was no green card available in EB3 at the time they approved the EB3. After a couple of weeks, the Ombudsman was able to get back to us and actually confirmed that USCIS had allocated that EB3 number to that file many months before they actually approved the file. So at a time when the EB3 date was current, they allocated the visa because they figured it was approvable at that point, but they didn't get around to approving it before the dates retrogressed, and then it sat on someone's desk for a while, and then finally several months later they ended up approving it. So it was a proper approval. So we didn't need to take any action on that case. What about the situation where they did not submit an interfile to transfer to EB2 and they end up getting an approval in EB2? How is that working? That's because the USCIS is telling that if the EB2 approval is there, though, they have an authority to pull that EB2 approval and give the grant the green card to the people. Now, Emily, I've seen this in two different scenarios. One of the scenarios is the same company has an EB2 approval, which seems to be clear. They have an authority to pull it out. There are some scenarios where they have an EB2 approval with a different company. When we inquired about it, the officer is telling that they have an authority to pull the I-140 approval, which is not revoked. They can pull that priority date and still give the green card, though. Of course, my client doesn't want to pay extra money to go challenge the USCIS decision because it's approved. One thing, of all these inquiries that we made, Emily,
What my suggestion to the people is that I do not want any of these people to make those inquiries anymore. I know you made it, I know I made it, those inquiries though. I do not want to make a record asking the USCIS to challenge them. Why did you approve my green card? Because it may become a little bit problematic at the time when they go for citizenship. If you keep challenging these decisions, I would rather not want to do anything, preferably though, but consult a lawyer before you consult the immigration though. Don't challenge them that why did you approve my green card in the wrong category? Why did you approve this? So you're telling them why did you approve the green card? That's the only thing they listen though. They don't listen in the wrong category, right category. And it's not easy for them to just, oh, here's the thing, I'm going to make a change. That's not going to happen with the USCIS. Yes, in the initial stages, we did consult because we were very confused how the things are. Now we understood the system a little bit better. We don't want to challenge the decision of the USCIS, especially when they approved your green card. Obviously, if they deny it, then it's a different issue though. But when they approve it, we don't want you, and we don't want you to, without consulting a lawyer, we don't want you to directly go to USCIS. And if your lawyer is telling to contact the immigration to fix it up, we recommend to have a second consultation so that you get the proper advice, and then you can make an informed decision. Once you have two lawyers telling two different things, you can make an informed decision. Because most of the time, if not all the times, immigration is telling they are right. And why do you want to prove them wrong? So by creating a service request, by filing an I-90 form, and by contacting the Ombudsman, by contacting the USCIS, we don't want. Now, we may have done that before because we didn't understood the process before, but now we understood the process. We don't want you guys to contact the USCIS. Ombudsman, Congressman's office, if you get the green card, contact the lawyer first before you make any decision. Any other scenarios, Emily?
Nope, I think that covers it. But so
there are some cases, Emily, where the dependents are getting approved first,
true, yeah.
And the main applicant is not getting approved. I'm still telling the people that, hey, maybe it's not worth for you to contact. Let's wait until you get the green card. I also don't want these people to travel outside the country if the main applicant did not get the green card, though. That's what I'm suggesting them to do. So please do not contact this. You're saying something in there.
Yeah, I was going to say, since now we see USCIS sometimes utilizing that EB2 I140 approval even from an old company, does that mean people could start doing this interfile request with an old company's I140 approval?
You mean to say the person worked with company A. Let's say the priority date is January of 2014 with company A and EB2. Then they joined company P and they filed under EB3, got the I-140 approval, filed the 485 under EB3. Can we do the interfile using the company A's I-140? We have told many times you cannot do it. We previously told. But then the USCIS is suggesting us, there is an I-140 approval with the previous company. Do you want to use it? Do you want to use it? And then we did some experiments saying that, yeah, let's respond to the RFE saying, yeah, I am okay using the EB2 approval of the company A, even though company A never signed the 485J supplement, even though company A is not responding to the RFE, and we got some success. Now, not all cases, some of them are pending, some of them are success. USCIS is indicating though. So I would go with company A's I-140 approval under EB2 and then file a 485J supplement. And at the most, what can they do? They will deny the movement upgrading of the EB3 to EB2, but I don't think so they're going to deny the entire application. In fact, they're approving the application under EB2, even though employer A never signed it. USCIS in their RFEs are pointing at, hey, buddy, you have an EB2 approval, why didn't you get it? And the USCIS, under great pressure, thanks to all of you guys writing the letters to the Congress, they want to get the 280,000 figure somehow, and they are trying to help you out to get you the green card. Let's help them achieving their 280,000 green cards, Emily. That's the way I am approaching right now. I was a little bit cautious before. Yes, we told you cannot do it. Then we told we were neutral. Now we changed because of how the USCIS is behaving, how USCIS is proceeding in these particular cases.
Yeah, because I don't see any downside to trying.
Yeah.
The worst case scenario is you're still in EB3, which
Yeah.
you're already there, so you're not losing anything.
Yeah, you have nothing to lose, only to gain if you use the company CIS I140 approval. Emily, on the green card process, you said some of the congressmen and the senators are not happy with the process of the green card. Now, what do you advise people who are on student visa, who are on H-1B? When should they start? According legally, Emily, that if you file a green card application before they touch the 6th year and they get their I-140 approval, they can extend their H-1B. So should they wait for the 5th year or almost 5th year to file for the green card? Is that how people should behave?
Not anymore. We definitely used to do that, but nowadays there's not enough time to get the prevailing wage determination and do the recruitment and file the perm to make sure that it gets filed before you enter your 6th year. So you really need to be starting this process no later than your 4th year of H-1B, not in your 5th. Start it in your 4th. Now, even better, start it as early as possible. You don't have to be on H-1B for any certain length of time before you're eligible. You're eligible even before you're on an H-1B in most cases, if you have a company that's willing to do that process. So the earlier you can start, the better, because that's going to be your priority date. The earlier the priority date is, the sooner you'll be able to get the green card, because you're a little bit ahead in line. We know it's a very long line, but at the same time, you need to make sure that you're able to get those extensions beyond the 6th year. We have so many people that wait till the last minute and then they end up maxing out, and then we've got an emergency. Okay, how do we keep working if I'm going to max out? I've got to take some strategic vacations, or I need to try to recapture the few days that I have left to be able to extend or change status to something else so that I can get back to H-1B later. So that's a lot of things to do in the very last minute when processing times for everything are long. So please start in your 4th year at the latest.
I disagree with you, Emily, on this. When I came to United States, though, I came on H-4 visa. And the first day I was in United States, I was really confused. It's 7 o'clock, it still doesn't get dark. I couldn't understand with my brain. Back in those days, the internet was not there. I didn't know that it doesn't get, until 8:30, it doesn't get dark in Atlanta. This was in April, so I was really confused. But the next day morning, Emily, I called up an immigration lawyer. I asked her, how can I get the green card faster? So the advice that I tell people is, as soon as you enter, after you enter into the United States, give it 1 day, guys. Not on that day. Call, try to get the immigration, get the green card immediately, though. Because if they apply the green card in the first year of their H-1B, then their spouse will get a H-4 EAD, and they don't have a tension of moving jobs, because while the green card process is going on, you can't move a job. I mean, that's another thing that you have. Initially, when people get a job, they're going to stay there for a while, and that's a good attraction for them. And I advise some of the people, though, hey, why wait until you get the H-1B? If you're an OPT and STEM extension, you got the job and the company is willing to file a green card application, you can. There's no need for you to be an H-1B to file a green card. You can do that before too. Emily, you have been pointing out that it's taking a long time for getting. We are advising people, okay, previously it was taking 6 months, the entire green card process. Labor and I-140 process was taking. And now, how much time is it?
Now it's 18 to 24 months. 18
to 24 months. And what would you say when you go to 24 months? Will you stick with this statement or will you change it?
Yeah.
So, yeah, obviously, Emily might change, things might change. So it's always better to apply for the green card as a, and don't forget that you may even get the green card too. It's not just extending the H-1B, it's not just H-4 EAD, you may even get the green card. Look at the numbers though. 1 day sometimes make a lot of difference. The priority date is December 1st, 2014. Oops, what if you filed on December 2nd of 2014? you can't file a 485 application. That's how hard it is. So the earlier your priority date is, the better you're going to get the green card, the better your spouse is going to get an H4 EAD. You will have more independence. If you want to move out of the job, it's going to be easier for you, as you already know that once the I-140 is approved, 6 months has been passed, you can move to a different company, use the same I-140 to get the H-1B extension. So I would advise people not wait until 4th year, start when you're on OPT, if not on STEM extension. If you can't do all of that thing in the first year of H-1B when you got it, you start the green card process then, you'll be better off compared to the other people. You'll be better off in the priority date, your spouse will get the EAD, you'll have more freedom. It's worth that investment as soon as you can file the green card application. Emily, the questions that are coming, Kumar from YouTube, I want answers from you. Hopefully, so they're going to use the entire 280,000 green cards. What do you expect the priority date movement in October of 2022?
Oh, goodness. Yeah, it definitely is not going to move before October because USCIS has come out and said they believe they have enough demand to use up all these 280,000. In terms of what happens next, I feel that maybe EB3 and EB2 are going to get closer and closer to having the same date. Maybe we'll get into, mid-2015 in EB2. I don't know if that'll happen in the final action day, maybe the filing date chart.
I'm expecting the filing dates, yeah. So what should people do, Emily, if their priority date is in 2015? Is there anything should they get the medicals right now?
Yeah, I don't recommend getting the medicals now because they're only valid for 60 days if you have not yet filed the 485. But you can make sure one of the biggest hurdles people have is their birth certificate. So make sure that you have the correct format of your birth certificate. You have it. If you don't have it, if it wasn't registered, make sure you get that non-availability certificate, and then have affidavits from family members or close family friends that can confirm all the details of that. Look into the secondary evidence that you can provide to go with that birth certificate. That will help you avoid the request for evidence later, which definitely improves the processing times for your 485. If you have recently changed jobs, and your I-140 approval is with your old job and your new job, hasn't filed the perm yet, or is that still in process, you may want to start talking to your old employer to see if they would be willing to support the 485 or have you go back to them so that you can file the 485, because we saw a lot of people in October 2020 kind of taken by surprise when the dates moved so much and they had just moved jobs and then they missed the boat. Because they weren't able to go back to the old employer to file. So those would be probably my two top things that you can start doing now to prepare.
Emily, are there any immigration bills, this question comes from Vijay, that can get the green card faster? Is there any reconciliation or anything that you think are possible, or take the per country quota limit off, that can get the priority date moved a little bit?
There are bills, mostly in the House, but the potential for them actually getting to the floor of the House is quite low. And beyond that, getting the same provisions from the Senate, that's even lower, especially as we're into an election year. So it does not look good for that. I think one of the areas maybe in the budget where they're trying to make sure that green cards aren't wasted anymore, so it would stop the spillover from happening from family base going forward, but it would also bring back those 80,000 that we wasted last year, plus several 100,000 that have been wasted going back to 1996, I think. So that would be helpful, but again, seeing that happen in the Senate is where we're going to have a hard time.
At this point of time, guys, we want you to focus more on using the green card applications right now to the fullest extent that we had. When the bill comes to a place where we think so that it has a chance of going through, that's when we will start requesting you to write the letters. We'll draft those letters for you. But if it's just, there are a lot of bills that are floating there that doesn't have a chance, we don't want to use your energy where we don't think so it's going to be fruitful. But if there is any fruitful bill that we think so has a good chance of passing, then we will come to you guys That's the reason you need to tune in to Reddy Neumann PC every week so that we'll update you based on how the things will go on.
Vivek from Facebook wants to know, can we go on a workcation, working from a vacation spot for a few weeks while you're on H1? Unfortunately, I think there's a couple of problems with this. Number one is your LCA only allows you to work in the location that it's certified for. So you're not able to move to another location and work from that location. That would be a violation of the LCA regulations. Now, there is a short-term placement provision that in some situations allows you to work in a different location for up to 30 days without filing an amendment of the H-1B or a new LCA. But those are very particular situations where the employer has to actually, number one, pay the higher wage. If the prevailing wage is higher in your vacation spot, they actually have to change your wage to match that higher wage. And they also have to provide you with the costs of you working from that location. So it is not as simple as just, oh, I want to go on vacation and I'm going to work from there. Technically, no, the LCA is not valid for any other location except within your MSA. So be very careful with that.
I mean, what are you expecting the spillover next year?
So we don't know exactly how many green cards the State Department has approved, either in employment-based or family-based. What they are saying is that they've adjudicated double this year where they were at the same time last year.
Is that you're speaking about employment-based or family? Because the spillover will come from family to employment.
Right, right, and they didn't specify.
Okay.
So this was coming from the ALA conference where we had State Department officials there, and so they were just talking about basically saying how much better they are this year compared to last year, which last year was horrible, so the bar was set pretty low. So there's definitely going to be less spillover. I'm thinking half as much as what it was.
Oh, half will be good. So you meant to say about 70,000 spillover?
Maybe 50 to 70.
Okay. Yeah, somewhere around that is what. Another suggestion for you guys is that if we don't get especially the Indian nationals don't get the green card by September of 2023, and if the COVID doesn't continue, hopefully so, practically Indians will be restricted only up to about 10,000 green cards approximately. The problem will be that every year out of the H-1B, 85,000 plus we have L1s and other visa people will come in. That we get almost 60% of this H-1B out of the 85. And then you have the exempt H-1B, so almost like 100,000 H-1Bs, we get 60,000. And we get only 10,000 green cards. In that, family members are included. So it's only 5,000 families get the green card out of the 60,000. So every year, there's a backlog of 10 plus years every year. So because we have these excess green cards that are available last year and this year, the dates move. So if the dates don't move in October of 2000 and I mean, all the way to maybe August of 2023 though, and practically these people will never get the green card. Will never be an adjustment of status unless there is a change in the law. So that's the reason there's a lot of push. We want to use these green cards. But that is a fact, guys. I mean, if the law doesn't change, though, if you guys don't get into the adjustment of status by about maybe September of 2023, it may take a long time for you guys to get the green card. Unfortunately, that is how the situation is. But there are other benefits of applying for the green card, like H4 EAD, H4 H1B extension. So there are a lot of other benefits also. And who knows, law may change. And who knows, there may be another COVID coming in. You never know. Hopefully not, but it can always happen. We didn't expect it COVID. We didn't thought. We told people how long it's going to get the green card. You told Emily it's going to take 100 years to get the green card. All of a sudden we changed it. And these things will change. So you just have to apply for the green card as early as possible.
Raj is facing a common situation right now. He has a priority date in EB2 in August 2013 and recently filed another EB2 petition, but it was approved with the wrong priority date on the approval notice. So they didn't port the old priority date with probably the new priority date of the new labor certification. We're seeing that a lot right now. He wants to know, should I wait for them to correct it or send in my 485 petition? Don't wait for them to correct it. It will take them weeks, if not months, to send an updated approval notice. and you may miss the boat by then. So what you can do is when you're filing your 485, you need to make sure that there's a note in there, bright colored piece of paper, or highlight, write all over it, make it clear that this is the wrong priority date, document what the correct priority date would be. I put it in double envelopes and I put in the inside envelope, please don't open this in the mailroom, please provide it to a supervisor so that it doesn't get rejected in the mailroom. So as long as you can make it past the mailroom, you should be fine, but you do need to have some extra things done on that 485 package to make sure that it can get past the mailroom.
Varun Parchuri, my wife and I received 2 separate RFEs from Miami field office. Is it okay to respond RFE with in the same FedEx? Yes, it's perfectly okay. Not only it's perfectly okay to do in the same FedEx, it's strongly advised to put in the same FedEx. Because you know how this USCIS is, they will, once this and that gets separated though, it may not reach the file properly, it may go. So I would strongly recommend, if it reaches together though, then it goes to the same officer, it gets adjudicated faster. That's a better way of responding, is one FedEx, not 2. Since it came from the same office, this is our advice. And one another thing I want to advise people is that if you are getting any RFP for the I-485, try to respond ASAP, guys, because they are in a rush to give you the green card. Let's help them achieve their goal. USCIS goal is to give the green cards for 280,000 employment. We should cooperate with them in achieving those things. Emily, I have noticed some of the things. I was on vacation, and then we got emails from the USCIS officials saying, "Hey, your client did not respond to the RFE. I didn't receive it."
Oh wow!
And then of course the client we were very fast in responding, and I checked today their status. Their status got approved. I mean, they are already the officer is in a pressure to approve the green card.
Mm-hmm. Yeah, and especially if you are expecting the RFE on the medical. For cases where you've already filed the 485, if you get the medical now, it's going to be valid for 2 years from the time the civil surgeons signed it. So you don't have to worry about the 60-day expiration date. So you could get the medical now, so that the day you get that RFE, you just mail it out, so you're avoiding any further delay.
And if you have not submitted the medical and you see online that RFE has been issued though, boom, I'm going to the doctor next day, sitting in. And please don't go to any doctor. Speak with this doctor's office, check with them how long it's going to take for them to get the medicals. I mean, some of them are saying it's going to take 2 months for them to issue medical. I don't know why. And some of them will issue in 2-3 days. So please check with them, call them, inquire them. If needed, go travel to a different city where you can get the medical report faster. That's what I would do if I were you. Yep. Check with your friend. If that friend got it in 2 days, you need to fly to Dallas, go there.
Volodymyr says, I have an EB2 pending adjustment of status and recently got the medical RFE, already responded to it a week ago, but then yesterday the online status changed to request for additional evidence sent. What can we expect from this new RFE? I would not automatically assume that there is a second RFE. That seems way too fast for that to be happening, and we do see a lot of times where the online case status maybe doesn't update, especially if it's coming from a field office. I have many cases where we didn't get an update at all when they sent that RFE, and then when we responded back to it, it didn't update at all. So it's very possible the update saying we sent you an RFE is them sending you the medical RFE from over a week ago. So it might be too soon to tell, but it's very possible that there is no second RFE, because usually they're pretty good about putting all the issues in one RFE.
Mr. Chowdhury from YouTube got the green card. Congrats. They printed the wrong priority date. They printed the priority date of the 5. Should you raise the service request for correcting the priority date? No, don't do that. Contact a lawyer before you contact the USCIS. They may have done it wrongly, but sometimes you want to poke it, you want to correct it, you need to file an I-90 and then send your green card to them, which is not a good idea. Then you have to get the passport stamping. I don't think so. I would recommend that you do any of those activity. Contact a lawyer before you contact the USCIS.
VK says his H1 was extended till 8/24/24, but the H4 was only extended to 8/14/24, and the H4 EAD 8/23/24. 3 different dates. Did get the visa stamped for both of them till 8/24/24 and wants to know, do I need to be concerned about these dates not matching the H1, and can I use the EAD? I don't see any problem with you using that EAD. It is valid even though the end date doesn't match the H1. You can use it up until the end date on the EAD. If you've got the H4 stamped, when you came back into the US, make sure you go online and check your online I-94. It's very likely that they actually gave you the correct end date to 8/24/24. So it may not be that much of an issue actually.
Question from Praveen Kumar. Emily, this question comes to me very frequently. Does EB1, EB2, and EB3 matter when the green card is processed after submitting the I-485 and biometrics? No, I don't think so for the process. There's also another question that I get, Emily. Does it matter if I get the green card in EB1, EB2, or EB3?
Not at all.
Not at all. A lot of people get, oh, I got it in this category. They categorized me under EB3, which is a lower category. They allocated my when it was current. It doesn't matter whether it's EB1, EB2, or EB3. It doesn't matter, guys. The only thing that matters is if it's an EB5, that's definitely not good at all. The reason why EB5 is not good is that it's only valid for 2 years. And to extend that 2 years green card, you have to go through a lawyer and a lot of documents though. But when you get a green card for EB1, EB2, EB3, it is valid for 10 years. And it doesn't mean that after 10 years, you'll have to apply again just like the way EB5 people do it. It's a simple online I-90 application. Go fill online, you pay the money, and then green card gets extended. So definitely EB1, EB2, EB3, they all fall into the same category. You don't have to worry about it.
Raul says he filed the I-539 online for an H4 extension, and USCIS uploaded the receipt notice online, but then he hasn't received any communication after that. Is this usual? Well, yeah, the I-539 processing time is anywhere from 6 to 12 months at most of the service centers right now. So you can check the online case status, check your receipt notice to see what service center is actually processing the application, and then look up the processing times. But it's very likely, other than the receipt notice, you will not hear anything until they issue the approval notice, and that could be up to a year.
Ashwini Singh, my work address has changed in I-485, 485J. Do I need to update it on I-485, 485J, 765, I-131? No, you don't need to. Only if your address has changed, you need to update AR11 with all the forms that you're discussing about, but not if the company address changes.
Emmanuel says, I recently received my green card. Should I withdraw my I-130 family-based petition, which has not yet been approved, or leave it as is? Will there be any impact? There's no mandatory requirement for you to withdraw it, but number one, only the petitioner can withdraw it, so it's the person who sponsored you. I might recommend withdrawing it because we need to free up these officers to be able to actually work on cases that need to be adjudicated. But other than that reason, there's no reason. You can go either way with it.
Ms. Singh, Sukanya Singh is asking a question. My husband interfiled from EB3 to EB2. Final action date is current. Can you tell me how long it's going to take to get the green card? Anywhere between 1 month to whatever time, the end time I never give it. Typically, if you interfile though, it's ranging anywhere between 3 months to 6 months is the normal thing that we're expecting. There's a lot of rush that I have to tell you, Sukanya, is that there's a lot of rush right now for the USCIS to adjudicate these applications. The first sign that you need to look into is that if your application is in Texas or Nebraska, if they move to the National Benefit Center, then you are in a good position to get a green card. Texas and Nebraska, if the file has not been opened there, they're not going to open now and approve it. If it's already open, some action is going on, they may approve it, otherwise they don't approve. So first step is for them to move the National Benefit Center. And there is nothing you can do right now to help them move your file to the National Benefit Center. You just have to wait and see.
DP got an RFE for an employment offer letter from the field office and replied a month ago, but the online case status is still showing the RFE was sent and it has not been updated. What steps should I take? There's no steps to take. That's completely normal, especially with the field offices. They don't generally update the online case status when they issue an RFE, when they receive the RFE. Probably you won't see any updates until the approval comes, but there's nothing you can do to tell them to update it.
Debasis has this question. Considering the current visa stamping situation, can we apply for the I-765 I-131 for a 7-year-old kid? Absolutely, you should. I'm assuming that you filed the 485. For all the 485 applications that we file, we do include the 765 and I-131s. I mean, that's, and people ask, my kid is not going to work. Why do I need I-765? We answer them simply this. Hey, all I'm requesting you is give the passport pictures, 2 of you, for your son. And that's all I'm requesting. We don't charge any money extra for it. So we don't give any discount also if they say, I don't want I-765. So we just include it. So it's always better to file I-765 and I-131 when you file the 485 application.
Sachin says, I have an EB3 I-140 approval in an earlier perm that was approved that has the same qualifications that matches on my EB2. Can I use that same perm to apply in EB2? So if I'm understanding, your EB3 I-140 was filed based on a perm that qualifies for either EB2 or EB3. If that's the situation, yes, absolutely. You can file a second I-140 in the EB2 category using the same perm as long as the company is willing to do that. Note that you can't file it in premium processing. Once you get the receipt notice, you can try to upgrade it to premium after the fact, and make sure this is filed as a new filing, not an amended petition. There's no reason to do an amendment unless there's a successor and interest situation.
Vijay has this question. Can my wife file a EB1 self-application if she's an H4 EAD? Absolutely, she can. She doesn't have to be an H1B to file an EB1 application.
NAG451 says, do we need to apply for a successor of interest if the company name changed when filing for the EB2 interfile after the EB3 downgrade? If it's just a simple name change, there's no requirement to actually file an amended I-140. In that situation, you just need to document the name change. If it was an actual successor and interest situation, then yes, the EB2, the EB2 does need to be amended in order for you to take advantage of that EB2. Otherwise, you would use AC21 to move your green card to the new company, the successor company, but it would stay in EB3.
Emily, one question that I have is that people want to go to Africa, Nepal, or some other country for the appointment. Can they go?
I think technically yes, but practically no. Most every single country is still backlogged, and they're only giving appointments to the people that are resident in their country or their own citizens. I've not really seen many people doing third country national processing anywhere in the last 2 years.
If they give an appointment, please make sure that you don't mention that you're residing in Nepal, which would be a lie and a misrepresentation. If in rare circumstances, I've seen some appointments in some African countries and other countries, yeah, if they give it, you can, but they are promoting right now only local people rather than actually third country national. That's what it's called. We call it as third country nationals.
Mayur says, my L1B blanket visa expired and my attorney extended my L1B stay with that I-94. Now I want to apply for visa stamping. Shall I apply for an L1B blanket or an L1B individual visa? It depends on how they did that extension. So you can extend with USCIS under a blanket. So when the company filed the extension, if they submitted an I-129 plus an I-129S, then they would have given you an approval notice of the I-797 with your new I-94, as well as a stamped I-129S, which shows that you're under the blanket. And then you can use that stamped I-129S to apply for the new visa under the blanket. It doesn't have to be, but it all depends on how that extension was filed.
Guru Karnam is saying that he got his green card. Thanks. Wish you best of luck in your future endeavors. And keep writing letters to the congressmen. Even though you got the green card, we still need to help our other fellow beings who've been waiting just like you for a long period of time.
Harsh says that the employer is filing my I-140 with the consular processing option. Is that compulsory to specify the consular post on the I-140? No, it's not. So on the I-140 petition, it only asks, are you intending to adjust status or are you intending to consular process? It does not ask you what post you want to process at, because they automatically will send it to the post for your home country.
Emily, just a small debate with you on with regards to EB3 has moved by a month. What do you expect going forward?
I do expect it to move in October. And the reason for that is looking at the number of I-140 approvals that are after 2015 in EB3, it's very, very low compared to EB2.
Of course.
Like 5,000 to 6,000.
Right. You mean to say that 75% of the I-140 approved are EB2,
Exactly.
less than 25% are EB3. That's been the trend before too.
Right.
But what about that when the spillover happens from EB1, it goes to EB2, it doesn't go to
Right.
EB3. So the number of allocated green cards are more in EB2 rather than EB3.
Correct.
Okay, but yeah.
I think the dates are going to end up being the same at some point.
At some point.
If the Department of State was smarter, I think they would do that on purpose so that they can avoid this whole downgrade mess.
They didn't know
They
that.
should have. I mean,
At the time when
they
did the September of 2020, Emily, they only looked into how many I-140s were being approved for Indian nationals, how many of them are EB2, how many of them are EB3. Oops, EB3 is less. Let's move EB3. They haven't used their brains at all.
I don't know what they were thinking.
They haven't used their brains at all. I don't know if they don't, and I don't know if the USCIS people or the State Department people which control the visa numbers, I don't know if they know what a downgrade is before September of 2020.
They did, because they always did it for China, and they talked many times in those check-in with Charlies that Ayla always had. He would mention the downgrade and upgrade situation. So I don't understand that at all. And maybe you just didn't think that many people would do it. Maybe you didn't think that many employers would be willing to do it.
To an extent, Emily, I was expecting the small employers to do the downgrade. I wasn't expecting the fan companies to actually downgrade the application, though. I thought they would not do it, though, and then they started doing it. When the dates are moving a little bit here and there, especially for Chinese nationals, I haven't noticed that the big company is doing it, but when the dates move, they got into the bandwagon and started doing it. That's probably one of the expectations I'm thinking from their side.
Amit says, we're not able to get any appointments in India, Mexico, or Canada for stamping. Is there any way we can inform the State Department that it's impossible to get an appointment right now? I think the State Department is aware of it. I think maybe you need to, again, write a letter to your congressman or senator's office telling them that, hey, you need to push the Department of State to make more visa appointments available and push them to utilize what they've been authorized to do in terms of Dropbox. The problem is, although the State Department is telling the consulates, you have the authority to do Dropbox for all these cases, it's not mandating the consulates to actually do the Dropbox for all of these cases. So they're not actually utilizing Dropbox for as many people as they could. But the only way to really push them to do that is to reach out to your congressman and senator and get them to urge the State Department to put more people and make these appointments more available.
Question with Best Buy from YouTube. His spouse got the primary applicant didn't get the green card, the spouse got the green card, what should I do? I would wait for a week or 10 days, and please do not contact the USCIS, do not contact the Ombudsman, do not contact the Congressman. And if you intend to do any of those things, first contact a lawyer. That's first, I want you to wait for 10 days to see maybe yours is also approved. It's not reflecting. If yours is approved, then of course, there's no action. If not, before you contact the USCIS, contact an immigration lawyer.
Siva says the I-140 was withdrawn after 180 days, and that was an EB2. Is there any possible chance to apply the I-140 again with the same employer using the same old perm? Yes, absolutely, if the employer is willing. So let's say you were working with company A, got your perm approved, got your I-140 approved, and then a year later you decided to move to company B, so company A withdrew your approved I-140. If company A will have you back and is willing to do that, they simply need to refile that I-140 petition using the same perm. They don't have to go through the perm process again, as long as the job location is the same, the job duties are the same, title is the same, and salary offer is the same.
Sridhar has a very interesting question. He says that he has been promoted, and now the company's lawyers are telling that they need to do a perm again. Is there a workaround for this? Absolutely, there's a lot of different workarounds. A natural progression in the job is perfectly okay. They don't have to file the perm again. And sometimes, even though you have moved to an upper level position, if the previous position is still open for you, still that is fine too. A lot of these FANG companies, when you get promoted, FANG, when I said like Facebook, Apple, Microsoft, these are the companies, they don't file one more perm application though when you get a natural promotion. Obviously, if you move from IT job to be a lawyer, then definitely that doesn't look to be a natural promotion though. But if you're moving from software developer to the senior software developer, or a software a manager within that particular department, that's a natural promotion. I mean, you can't expect a person to come and do the same job every single day. The only people who do it are not people. We call them robots that are designed by you guys engineers. Especially they do every day, put this one there, that's not every day. The job is different. Does every time, every Tuesday we speak the same thing? If we speak the same thing, let's copy and paste the same thing. Every question is different, every answer is different, every solution is different. So definitely with a natural progression in the job is absolutely needed. It's perfectly okay. They don't need to file the perm. But it all depends on the lawyer. What is legal is natural progression. It's perfectly okay. But the lawyer want to make more money, then it's a different issue though. You may want to sort it out with your employer and probably cut this video and show it to them.
Sandeep wants to know if he needs to refile the advanced parole for his wife. His EAD and AP has not been approved yet. Applications are still pending, but she traveled to India on her valid H-1B. Yes, so USCIS is still denying the I-131 application if you travel while it's pending. So even if they haven't denied it yet, they very well might likely do that. So once she's back in the US, based in her H-1B status, she can turn around and refile that I-131.
Any formula to get the I-485 case transferred to NBC documentarily completed since April of 2022? No. Murai PK, no. We don't have any formula that we know that we can get things get transferred to NBC. If you have not filed the medical, which I see that you filed the medicals too, so your I-140 is also approved. Some of the people that we suggest that even if you're first, if you have an EB3 approved though, and then later on, first you have the EB3 pending, later on you interfile with EB2 though, they are still not moving the case to the National Benefit Center because your underlying I-140 for EB3 is not approved. Now, in the USCIS frequently asked questions on their website though, they say that they can approve the EB2 even if the EB3 is pending, but we haven't seen that. So we normally are recommending people to do the premium processing of the I-140. That's the only thing that if you have not done it, we recommend you to do it.
Yeah, Kumar has that exact question. He wants to know, does the EB3 I-140 approval have any bearing on the interfile to EB2? Because they see no progress after this interfile.
The USCIS website says, no, it doesn't have any bearing, but do you believe that?
No, I don't, because in practice, they are keeping that EB2 application at the service center where that EB3 I-140 is pending, and they're not transferring it to the National Benefit Center because of that pending I-140, even though they don't need it to adjudicate the 485.
Also, Emily, I noticed that even when we refile the application with previous EB3 is pending, and now we refiled it under EB2, they still are not transferring because the I-140 is still pending in Texas Service Center. Even though the receipt notice is coming from National Benefit Center, they're transferring. So the secret mantra is definitely getting the EB3 underlying I-140 approved. That definitely, if any of you guys have EB3 still pending, get that approved. And let me tell you one thing, they are taking your premium processing fees right now. Previously, it was dilly-dallying things. Sometimes they used to take it, sometimes they don't used to. Now, they are accepting the premium processing, so please get your EB3. That is the only secret formula that I can tell. Get your EB3 approved in premium processing.
Pavan wants to know, is it the intention of USCIS to give green cards for all of the filed 485s and biometrics completed by September 2022 to hit their goal? All we know is they said if you filed by early June a standalone 485, meaning your I-140 petition was already approved and your final action date is current, they should be approving those by the end of September 2022.
Does FOIA bring the GC file to the top to adjudicate? No, we don't see that thing though. In fact, in one of the cases though, what we noticed, one or two of the cases, what we noticed is that the person that had been called for interview, when we filed the Freedom of Information, the interview was postponed, and the officer said that because the Freedom of Information, they have to send file back to the national office and have to bring it back. So it's not helping though. You know, these are all the things that we learn the things sometimes, guys, believe me. So definitely FOIA is not helping. Muralidhar has a good question. Is it better to file I-140 and 485 together, or is it better to file separately? Separately, not together though. If you file I-140 and 485, where does it go? It can go anywhere but National Benefit Center. And guess what? Who is going to adjudicate your 485? It's going to be only National Benefit Center. So look, all the people are trying to struggle to move their file from Texas or Nebraska to National Benefit Center. You, by filing an I-140 and 485 together, you are going into the lion's den with right mouth open. You're entering into the mouth by filing an I-140 and 485. Unless the priority dates are going back, you absolutely have to file the I-140 and 485. I would like to get the I-140 approved in premium processing, then file the 485 application, which will only go to National Benefit Center.
Deepak says his priority date is current for his I-140 that's with his previous employer. The perm is in process with the new employer, and he wants to know, wouldn't I be able to get an H1 extension for 3 years as earlier? Unfortunately, no. So a pending perm does not authorize you for a 3-year extension beyond the 6-year limit. Only an approved I-140 does. But when that approved I-140 has the final action date current, you're only eligible for 1-year extensions of your H-1B. And then if your final action date has been current for more than a year and you still haven't filed the 485, then that extension, 1-year extension, becomes discretionary. It's not mandatory that they will give it to you.
Anything else, Emily?
I think we are out of time for today. Thanks so much for joining us. Glad we didn't lose power during all of that. Be sure to check out immigrationgirl.com to take a look at our statistics that we're posting on when these 485s are getting filed, whether they were refiled, interfiled, downgrade, straight filing, which service centers are approving
when they move the file to National Benefit Center.
How long it's taking after that transfer to get the approval. We've got all of that information for you. Just to give you a better idea of what to expect. And of course, you can always subscribe to immigrationgirl.com, as well as subscribing to our newsletter at rnlawgroup.com that we send out on every Wednesday.
Thank you very much.